Good afternoon, colleagues. Welcome back to Legislature. The Legislature in Guam is hereby called back to session. We are under motions. Senator Perez, you are recognized.
Suzu's Masi, Madam Speaker, and to my colleagues. I move to place the nomination of Attorney Stephen Carrera to serve as a member of the Guam Environmental Protection Agency Board of Directors on the session agenda.
On the motion to place the nomination of Attorney Stephen Carrera as a member of the Guam Environmental Protection Agency Board of Directors, is there any objection? We're in motions, yes. On the motion, is there any objection? Seeing no objection, motion carries. Senator Perez, you're recognized.
Thank you, Madam Speaker. I move to place the nomination of Alice P. Sebastian Cruz to serve as a member, Classified Employee Real Estate Licensing Division, DRT representative of the Guam Real Estate Commission onto the session agenda.
On the motion to place the nomination of Alice P. Sebastian Cruz as a member of the Guam Real Estate Commission on the session agenda, is there any objection? Seeing no objection, motion carries. Senator Perez, you are recognized.
Thank you, Madam Speaker. I move to place the nomination of Meenakshi V. Hemlani to serve as a member of the Guam Solid Waste Authority Board of Directors onto the session agenda.
On the motion to place the nomination of Meenakshi V. Hemlani as a member of the Guam Solid Waste Authority Board of Directors, is there any objection? Please raise your hand. Seeing no objection, motion carries. Senator Perez, you're recognized.
Thank you, Madam Speaker. I move to place the nomination of Elizabeth Barrett Anderson to serve as a member of the Criminal Injuries Compensation Commission with a recommendation to do confirm.
On the motion to place the nomination of Elizabeth Barrett Anderson to serve as a member of the Criminal Injuries Compensation Commission, is there any objection? Please raise your hand. Seeing no objection, motion carries. Senator Perez, you are recognized.
All right, thank you, Madam Speaker. I move to place the nomination of Dr. Lisa D. Flores to serve as a member of the Criminal Injuries Compensation Commission onto the session agenda.
On the motion to place the nomination of Dr. Lisa D. Flores as a member of the Criminal Injuries Compensation Commission on the agenda, is there any objection? Please raise your hand. Seeing no objection, motion carries. Senator Perez, you are recognized.
Thank you, Madam Speaker. I move to place the nomination of Denise M. Mendiola to serve as a member of the Criminal Injuries Compensation Commission onto the session agenda as well.
On that motion to place Denise M. Mendiola as a member of the Criminal Injuries Compensation Commission on the agenda, is there any objection? Please raise your hand. Seeing no objection, motion carries. Senator Perez, you are recognized.
Thank you, Madam Speaker. I move to place Resolution 94-36 LS as introduced onto the session agenda. It's relative to supporting Government of Guam agency efforts to secure federal technical assistance and funding to eradicate snakes from Dano, also known as Cocos Island, to protect and recover Guahan's native species, and to commit to removing brown tree snakes from Guahan. Sponsored by myself, Senator Sabina Flores Perez, and co-sponsored by Senator Clinton E. Rangel.
On that motion to place resolution number 94-36 onto the session agenda, is there an objection? If so, please raise your hand. Seeing no objection, motion carries. On motion, Senator Blas, you are recognized.
Thank you, Madam Speaker. Madam Speaker, I move to place Bill number 140-36 LS as amended by the Committee on General Government Operation, Appropriations, and Housing. It's an act to add a new Chapter 9 to Title I of Guam Code Annotated relative to creating the Guam Humanitarian Service Award to recognize all support efforts by individuals for disasters or declared emergency operations and activities, as introduced by myself and all members of this body.
Yes. Can we just clarify the number 140?
140-36, yes, ma'am.
We'll just wait one moment for the clerks to locate that.
Madam Speaker, if I may.
Yes, please.
As the Committee on Rules Oversight, Madam Speaker, I will just note for the record that Bill number 140-36 LS, as amended by the committee, has been received by the Committee on Rules dated June 28, 2021 at 10:09 a.m. It is in review right now, and if I'm not mistaken, it has not been uploaded yet, just for the record.
That is correct, Senator Blas. Can we hold your motion
Yeah,
in
and I'll hold the
abeyance?
motion, ma'am, and when it does, then I'll reintroduce the motion later.
I'm sorry, can you repeat that?
I'll hold off on the motion until it's uploaded and everything, so we can make sure everything's germane, okay?
Thank you very much,
Thank you, ma'am.
Senator Blas. Thank you very much, Vice Speaker Munya Barnes. We're still on motions. Are there any other motions? There are no other motions. We are now in legislative concurrence. Senator Perez, you are recognized.
Susan Masi, Madam Speaker. I move to place in the voting file from the Committee on Environment, Revenue, Taxation, Labor, Procurement, Statistics, Research, and Planning the nomination of Attorney Stephen Carrera to serve as a member of the Guam Environmental Protection Agency Board of Directors with a recommendation to do confirm.
This is a motion to place in the voting file. Is there any objection? Seeing no objection, motion carries. Senator Perez, you are recognized.
Thank you, Madam Speaker. I move to place in the voting file from the Committee on Environment, Revenue, Taxation, Labor, Procurement, Statistics, Research, and Planning the nomination of Alice P. Sebastian Cruz to serve as a member, Classified Employee, Real Estate Licensing Division, DRT, representative of the Guam Real Estate Commission with the recommendation to do confirm.
On the motion to place Alice B. Sebastian Cruz's nomination into the voting file, is there any objection? Seeing no objection, motion carries. Senator Perez?
Thank you, Madam Speaker. I move to place in the voting file from the Committee on Environment, Revenue, Taxation, Labor, Procurement, Statistics, Research, and Planning the nomination of Meenakshi V. Himlani to serve as a member of the Guam Solid Waste Authority Board of Directors with the recommendation to do confirm.
On the motion to place in the voting file the nomination of Meenakshi V. Himlani as a member of the Guam Solid Waste Authority Board of Directors. Any objection, please raise your hand. Seeing no objection, motion carries. Senator Perez, you are recognized.
Thank you, Madam Speaker. I move to place in the voting file from the Committee on Health, Land, Justice, and Culture the nomination of Elizabeth Barrett Anderson to serve as a member of the Criminal Injuries Compensation Commission with the recommendation to do confirm.
On that motion, are there any objections? Seeing no objection, motion carries. Senator Perez, you are recognized.
Susan Masi, Madam Speaker. I move to place in the voting file from the Committee on Health, Land, Justice, and Culture the nomination of Dr. Lisa D. Flores to serve as a member of the Criminal Injuries Compensation Commission with a recommendation to do confirm.
On that motion, are there any objections? Seeing no objection, motion carries. Senator Perez, you are recognized.
Thank you, Madam Speaker. I move to place in the second reading file from the Committee on Environment, Revenue, and Taxation, Labor, Procurement, Statistics, Research, and Planning, resolution, if I can restart. I move to place in the voting file from the Committee on Health, Land, Justice, and Culture the nomination of Denise M. Mendiola to serve as a member of the Criminal Injuries Compensation Commission with a recommendation to do confirm.
On that motion to place in the voting file the nomination of Denise M. Mendiola, is there any objection? Seeing no objection, motion carries. We are now on consent calendar. There are no items, so we will proceed to the second reading file. In the second reading file, we are resuming on Bill number 93-36 LS. At the time that we recessed, Senator Taitigui, you had the floor.
Sijus Mase, Madam Speaker. I believe during the recess, we were looking at the language to ensure that the intent of this legislation on Bill 93, that anything that was prior to the passage of this particular bill, if it should pass, is not affected. So we use the word retroactive to ensure that nothing from the time it's signed will affect it. And I believe we were having some discussions on it, Madam Speaker, and I guess there are different interpretations. Over the weekend, I believe all of our colleagues received an email from, again, the real estate industry indicating that the additional language to the effect that the bill shall not have retroactive effect is, it wouldn't
Actually, it says here. Let me get this up real quick, Madam Speaker, since we received this letter from Kim Anderson Young. Okay. It says here in the email that we received, the letter, asking for support of this legislation. And I mentioned many times before, I support something like this. In most jurisdictions, there's not that power of sale that's incorporated, especially when it comes into a trust. And it's basically about a trust, that the trust shall have its summary on what a person can and cannot do with property. But of course, the Guam law, it's been in Guam law since the 60s, this particular law. So what we're trying to do is change that. But what we don't want to do is change what was already put in place, those intentions of individuals who put trusts together to ensure that the property stays in the family and that its intent was never to be sold. We don't want to open Pandora's box here, Madam Speaker. It's about ensuring that what was done in the past stays there. According to a letter that we received from Kim Anderson, she states that that 2105, Guam Code Annotated Section 2, 2105 states the effect of repeal and amendment. The repeal and amendment of any statute shall not affect any offense committed or any act done or right occurring or accrued or any action or proceedings had a commenced prior to such repeal or amendment, nor shall any penalty, forfeiture, or liability incurred under such statute be released or extinguished, but the same may be enforced, continue, sustained, prosecuted, punished under the repealing or mandatory statute as limited by the ex post facto and other provisions of the Organic Act of Guam, in which the event shall be enforced, continue, sustained, prosecuted, punished under formal law, as if such repeal or amendment had been made. Madam Speaker, I understand the section of law, what it says, but I think it still leaves room for interpretation, especially from Attorney Jackson, I think it was his name, who was part of, who was part of the public hearing. It's not appearing before the committee on here, but there was an attorney there that was there during the public hearing. And when asked the question whether this would be retroactive if it was to pass into law the way it is right now, and I believe his interpretation was yes. So I think, Madam Speaker, what I'm trying to do here is I have an amendment that I put into, had a legal type up for me, and I believe it might be in the amendment file, and it's very simple. Let's make it clear for whoever is trying to interpret this legislation, to make it very clear to any judge who's looking at documents put forth that they may try to debate. Attorneys are always finding loopholes, back doors for debate. And that costs a lot of money, Madam Speaker, so let's simplify it, which it simply says, and I don't know if everyone has it on their drive right now. Madam Speaker, can I just verify with my colleagues if they have it before moving forward?
According to the clerks, this is uploaded on the drive. But we can take a minute to locate it. Okay,
Thank you,
they've
Madam
got
Speaker.
it. They've got it. Please proceed.
Thank you, Madam Speaker. Madam Speaker, this is on page 3, section 4. It says effective date. This act shall be effective upon enactment, and this is where the amendment comes in, and shall not apply retroactively to instruments existing prior to the enactment of prior to the enactment of this act. It's clear, it's simple. Anyone who sees this in the law will know it does not go retroactively. And that's all this amendment does, Madam Speaker. It just clarifies it. It adds, in fact, it really does. It adds to this section that Kim Anderson had given us in her letter on GCA 2, section 21505. It reiterates it. So it's as simple as that, Madam Speaker. I support, as I said earlier, I support this legislation moving forward, on anything moving forward. But retroactive, we're opening Pandora's box here. Thank you, Madam Speaker.
Thank you, Senator. On the amendment to Section 4 on page 3, line 3, is there anyone who'd like to be recognized on the amendment? There's been an objection to the amendment, but is there anyone who'd like to be recognized to speak on the amendment? Senator Brown, you are recognized.
Thank you very much, Madam Speaker. I have to say, in looking at this bill, that probably for me, I'm undecided, and I voted in the committee not to pass this bill, primarily because I'm a bit concerned about what the outcome will be. If I had a bunch of families knocking on our door and saying, hey, we have a family trust and we're not able to move it forward because of this, and yet, I read it, okay, your family said yes, you could sell your land, or no, your family said you couldn't sell your land. We don't know how many trusts have been set up. We don't know how many trusts are going to be affected by this. And I did participate and listen to the testimony that was provided in the public hearing. But what concerned me, and as I relayed, Madam Speaker, because you were also there, obviously, at this public hearing, was we're only hearing from the real estate industry. We're only hearing from the attorneys from the real estate industry. And that's where my concern comes in. I'd rather have a broader representation because I am a bit concerned. What does this do to affect these trusts? Nobody wants to go to court if they don't have to. It's a very expensive, it's a very time-consuming process. We all talk about how justice is equal and here for everyone, but it's certainly not free. And for anyone who's had to go through the legal process themselves, especially on civil matters, it's a very expensive process. Very expensive process. People have sometimes to take loans up. People have to sell land sometimes, to have enough money to be able to pursue this. And I don't know what it is that we're effectuating ultimately with the passage of this legislation. If it's so cumbersome, why is it the legislative solution that's being looked at with regards to this particular issue to have it changed in the law? Because it wasn't explicit, the explicit words weren't used with the power of sale. Ultimately, everyone should have the right to determine if they're going to go through all the effort, and you certainly, Madam Speaker, more than any of us here, I don't think that we have any other attorneys here, are more experienced with regards to these issues. I'm sure, people have the right to decide, but if you're going to go through all the effort of a trust, I'm going to assume that you've decided how, and the reason why you put the trust in place is to decide how you want your assets to be used or distributed by your heirs, or any interested party you decide to pass on your property, your money, whatever the case may be, to those who survive you. And so I'm a little concerned in this process. I don't think it's as clear-cut as it's trying to appear here, that we're simply allowing, well, everything else in the language says, Mom and Dad wanted us to sell the land, but we don't have the words of the power of sale, therefore we can't sell the land unless we have a judge review it. There's a part of me that's not uncomfortable with that, even if it does cost a little more, because I am concerned. There are some cases, obviously, I don't know anyone on Guam, Madam Speaker, who doesn't have an extended family of brothers, sisters, cousins, whatever the case may be, especially when it comes to the division of public assets, particularly when it comes to the division of property. Tell me what local family hasn't gone through a headache with regards to that, or disagreements in the distribution of land, or the stories of one family member taking the land and selling it without clear title and causing a whole bunch of problems. I have heard it time and time again. Anyone, like I said, any one of us who inherit property, many of us are faced with those challenges. So there is no clear-cut view for me yet. I don't have a clear picture yet with regards to this bill that makes me comfortable in supporting it, because I don't know what the ramifications are. It seems like maybe it's a very simple thing. Oh, no big deal. Now we'll feed all these families. They don't have to go to court anymore. And we're all good. But when it comes from a particular industry, and I have nothing against real estate agents. I wouldn't have my existing home if I didn't have a real estate agent to deal with. But that's been the primary representation. Those are the ones that are reaching out and saying, hey, this is what we like, this is what we support. But I don't know what the ramifications are out there, because I don't know how many trusts are affected by this. I don't know if there's existing disagreements in a trust that otherwise probably should be, go to court, that we may be impacting with regards to this change, especially when we're midstream, when we're talking about trusts that have already been written and already been put in place. And granted, every attorney, we can't say every attorney, perhaps I'm sure in some of these routine issues have their cookie cutter write-ups, for these type of legal documents, but those things can be modified and changed depending, of course, on what the interested party is that's executing a trust wants to put in their trust. So I don't have that answer right now. It's pretty blank space to me. That makes it very difficult at this time, without really getting a full picture of this issue, to be able to support it. I always ask my question, Madam Speaker, when legislation comes before us, where is it coming from? Why is it here? And what special interest are we advocating it for? Because that happens a little more often probably than the people of Guam would like to think. Because we're all here to represent the people, but sometimes we're here to represent certain people when it's convenient for us. So I don't have a clear picture, and I feel very much that the amendment that Senator Tello has put forth is a compromise, so that at least moving forward for any new trust, if that's the desire of the individuals that are putting their trust together, and they say, well, now this is a law, their attorney advised them that this language is required if you want to have your heirs or the parties that are recipients of your trust want to sell the property, and you want them to sell the property, then we have to put this language in. It's required under law, as many other things that are structured with regards to the laws of our island. I don't have a problem, but I'm a little concerned. What are we affecting by this? And are there ongoing cases right now? Are there any cases under litigation that we might be impacting? When it comes to money, when it comes to land, wow, that's a different story. You have families that break up over things like this. So I don't know what the unintended consequences are. I mean, from what I'm hearing from those that are advocating, sounds pretty clear-cut, no big deal, let's just, change it. Everybody doesn't have to go to court, and we're all good. I just don't feel that. I don't see it. I don't comprehend it at this point. Although it make me supportive of dealing with the bill as it exists right now. I would support the amendment, and perhaps in doing so, maybe to give me greater clarity, because I'm not affecting anything retroactively, that I would support it. But I just wanted to relay those concerns, Madam Speaker, with regards to this particular bill, because that's just how I feel about it at this point. Thank you very much for the opportunity to comment on the amendment.
Thank you very much, Senator Brown. On the amendment, Senator Torres, you are recognized.
Thank you, Madam Speaker. I rise in opposition to the amendment, and I'd like to go back to why this amendment is flawed. It's a flawed amendment on flawed reasoning, for the simple fact that, and it was outlined a little bit in the message from Security Title as to why this amendment is not necessary and may actually cause problems. This idea that if you don't make it retroactive, you could open up a Pandora's box, you could create problems. That is not true. And the reason that is not true is because under 2 Guam Code Annotated Chapter 2 statutes, and this was also pointed out in Security Title's email, under Section 2105, titled Effective of Repeal or Amendment, when we repeal or amend any statute, it shall not affect an offense committed or any act done, or right accruing or accrued, or any action or proceeding that had commenced prior to such repeal or amendment. So, in other words, if, as it was tried to be explained to us, if the deed that conveyed property into a trust instrument contain the words with power of sale, then it's clear that that property has power of sale. Most likely, the trust instrument will also contain language in it that allows for power of sale or properties deeded into it to be sold, among other things. If a deed that transfers property into a trust instrument does not have the words with power of sale, but the trust instrument itself allows for a sale, is very clear, then it is the trust that determines whether or not. So whether we pass this law and it changes the requirement to have those words with power of sale is not going to affect whether, it's not going to correct something. In other words, if the trust says you cannot sell, you cannot sell. If the trust says you can sell, then you can sell. So, you know, insisting that you have to, there's a cutoff date for this bill for when trusts are created, when deeds are made, is really unnecessary because it's not changing anything within the trust. What it does do is it does, in fact, fix what is more or less an inconvenience, where if those words were missing from a deed, it requires the parties to go to the court to have the judge read the trust instrument and say, oh yes, in fact, you are allowed to sell under the terms of the trust agreement instrument. Under 2 GCA, Section 2105, you cannot pass a statute that will change an error or change something that was done previously. It doesn't mean that if we pass this bill today and the trust instrument says you shall not sell, that somehow you are going to be able to sell with this bill. That doesn't do it at all. It just takes away that one step right now in the law that requires you, if it doesn't have, the deed doesn't contain the words with power of sale, to go to the court to have the judge say, yes, in fact, you can sell or you can't sell. The trust instrument itself is what governs whether properties can be sold or not. It's the trust instrument itself, and it doesn't matter whether you change the statute now. All you're doing really is you're making it cleaner going forward. You're making it cleaner for people. You're taking away one instrument. Maybe there were situations in the past where people said, I don't want to bother going to court. I don't want to, and maybe it stopped people from doing that. But it won't allow somebody to do something in violation of the trust indenture. And that's what I want to point out. This doesn't make you do something that is wrong. It doesn't affect an offense committed. It doesn't make you do something that is not contemplated in the trust instrument. And so I strongly oppose to the amendment. It really has no effect because what we are doing is contained already and contemplated in another section of the law. And that is what we can rely on, absolutely. Thank you, Madam.
Thank you, Senator Torres. On the amendment, is there anyone else who'd like to be recognized on the amendment? Senator Duenas, you are recognized.
Sidus Mazi, Madam Speaker. Probably some of the comments I'll have were some of the same comments I was going to have on discussion of the motion. But since this came up, I guess I'll just state why I also am still a little bit confused. When I read the legal review, it appears to me to be clear when perhaps there's a conflict, but in the statute and what's being proposed here is basically to eliminate the two provisions of the ability with power of sale under trusts that have been put together. Now, the first section, Madam Speaker, with power of sale seems pretty straightforward. I was almost wondering if the proposed amendment on the bill was because it's the words "with power of sale." Because, of course, you can say many different ways when you want to say the trust as it's assembled has the ability to be sold, mortgaged, or otherwise, used by the beneficiaries. It's the second provision, elimination, Madam Speaker, that I'm having some trouble with. And that is when it's absent. I'm wondering what was the intent when the original statute was crafted. This law has been on the books for a long time. And I would imagine that those, Madam Speaker, who were assembling trusts, particularly if they're officers of the court, have their Juris Doctorate, not just assembling and putting together trusts for families who want to assemble a trust for various different reasons. Why would they have not been more explicit that I want to warn you, Tan Maria, that when you assemble this, if you don't put "with power of sale" in the trust and you pass away and the trust remains intact, it wasn't amended, it wasn't dissolved, the family's going to have trouble, or those administering the trust is going to have trouble if it's not just going to be divided interest amongst those in the trust. So, Madam Speaker, that is kind of where that's my crossroads, is not the provision in the law that's being lined through now with power of sale if it's contained. Because it could be said a different way, the ability to sell, the ability to mortgage, not those 4 words with power of sale. That to me is a no-brainer, right? If it's got language in there, that was the intent of the trust, pazagua. But on the second attempt to repeal the second section of the law, then you're saying, even if that the way I'm seeing it, then you're saying that even if it wasn't explicitly said, but it wasn't put in, it would still have power of sale. And so that's why I'm thinking that I don't see the harm in the amendment, because the amendment's just reinforcing the fact that it would be prospective. So I'm going to sit back and listen. I don't know if I was as clear as I tried to be. The only difficulty, Madam Speaker, with not having, and I guess I should just print it out if I want to speak to a bill, having our bills in the electronic format is I have to dive down and read the computer and come back up. But I think most are following that what I'm talking about is you have the 2 sections of the bill, 2 and 3. One is very clear that with power of sale is power of sale, no question about it. The second is, Section 3 would be if it's not there, then it was clear. I mean, this was written into law, Madam Speaker. And this has been the law in the land for many years, that without it, it can't be sold. And I would imagine the reason why the having to go to court is because under normal circumstances with a trust, not every trust, but under normal circumstances with a trust, you're going to have multiple heirs. And nobody's going to know what the explicit reason was if the omission is there. Was it intentional or non-intentional? You can only know that if a trust is trying to be executed and you still have the creator of the trust in good capacity to say, Ungan, that's what I wanted. Lo como estamos, pues, I don't know. And I would imagine that the going to court and the court decisions that were included under circumstances where there was no with power of sale as described in section 3, I think I'm being accurate, that when they're in court, you would assemble those beneficiaries to the trust and you would affirm that the will was of those who have assembled the trust was that the heirs benefit or the beneficiaries of the trust benefit in a way, whatever would satisfy life, happiness, and whatever the purpose for assembling the trust was, to include sale, mortgage, or anything of value to the trust. So I'm going to listen. As I think as many speakers have said, there's no issue going forward because the new law of the land, I would think, would still apply to those who have that awesome responsibility of assembling a trust. Generally, it's going to be real property and other assets, I'm sure. So I'll listen intently, Madam Speaker, but at this point, I don't know if, as rendered in the legal opinion, the additional language is superfluous given the ambiguity of this issue. What we're really doing in this statute basically is we have a legislative intent, we have the lining through of the two sections, which essentially just takes the body of law away, and then you have an effective date. So I'm hoping that we can get some additional legal discussion on the floor, but that's my at least concern at this point. Si Jesús Masi, Madam Speaker.
Si Jesús Masi. On the amendment, is there anyone else who'd like to be recognized on the amendment? Senator San Augustine, you are recognized.
Thank you, Madam Speaker. You know, after listening to my colleague, it almost sounds like you pass it as it is or you pass it with the amendment, it doesn't matter. That's my understanding. Number one, with the amendment, I support the amendment because I know of folks that are in trust and some of the members in the group want to sell, some don't want to sell. The whole intent back then, the parents said, no, and keep going down the line. That was the intent. But then some of the kids, as time went by, they felt that no, grandpa or great-grandpa wanted to sell it because wanted us to benefit, wanted you to benefit the use of the land, not the value, the use of the land. And with that note, and then at the same time, as our colleagues are saying, well, if you don't have the words, the power to sell, but it is written in the trust that you can sell, the court will decide it. Then so be it. Then so be it. Let the court interpret the law, the trust as written, and let's move on from that. But generally, I wouldn't want to go back on time and say that si tunwan malagona na paifamagona po bendita no na, but intention na gina tempo 1950, he never wanted his land sold. He wanted his great-grandchildren, his great-great-great-great, and so forth, to benefit the use of the land and develop it from there. And with that note, Madam Speaker, I'm in support of the amendment because it only protects the folks that are not here today. And everyone I've heard was real property. I would have loved to have heard folks that own, that are part of the trustee, not just real estate agents. I would, that because I've been in communication the whole weekend with a lot of them. Thank you, Madam Speaker.
Thank you, Senator. On the amendment, is there anyone else who'd like to be recognized on the amendment? If not, then Senator Taitui, you may close on the amendment.
Situs Masi, Madam Speaker. You know, Madam Speaker, being voted into office, I take very, very seriously. And I take it to heart, too. I know that the people of Guam, sometimes they don't know what's happening in this legislative hall, especially if something is coming up, that it hasn't been, advertised enough, or they just get busy in their schedule. But when they vote for us to ensure that we're going to have their best interest at heart. And if it means adding another layer of security, then we need to do so that we can look at our public in their eyes and say, we did everything we can possible to make sure that justice, fairness, and definitely those who passed, who had property that wanted their land to stay. A good speaker from Jigo hit it on the nose when he said, it's not the value, it's to take advantage of the land. And I believe, Madam Speaker, the first time I stood up and spoke on this, land is precious. It's all we have. And the Manamku, those before us, know that. They're wise in their older age. That money is not everything, but land is culture, is heritage, and most especially where we come from. And it'll stay in the family. The good senator from Afami Sinhanya, he definitely gave the explanation, the importance of this legislation with regards to ensuring that the intent of Tan Maria, if she did not put it in the deed that said power of sale, maybe it wasn't because she wanted it there. Earlier it said that this amendment is flawed. There's nothing flawed about being sure, to being clear. There's nothing flawed about that. It's about interpretation of law. What we pass here, and if it's challenged in court, they look at the intent of these laws that we pass, that we create. And when it's black and white and clear as day, this is not to go retroactive. There's no ifs, ands, and buts about that. It's clear. And that's what we want to do. Things that can go retroactive. Madam Chair, if you recall, years ago, when that actually happened, where it was retroactive by the Catholic Church, when we had that bill come onto the floor about crimes the church have committed in the past, retroactively. That happened. I think we all understand the respect of our Manamku, and what they decide to do is important, and to keep that in place. The good senator from Sinahanya also mentioned this has been in their books for years. If the summary of a trust, Madam Speaker, says to sell any property that you have, but they fail to indicate in the deed, when they deeded over property, power of sale, it's as simple. The law says it must say power of sale. It's just that simple, but it wasn't done. So what are we doing here today? Introducing legislation to change that and make it retroactive? I believe moving forward, Madam Speaker, I said I support this legislation, but I cannot support this legislation if it doesn't have this amendment that has the security of each of us who understand the importance of not changing the past. It's about moving forward into the future for the best interest. And I believe someone mentioned something about having additional attorneys come in. Well, our legal bureau said this is a way to ensure that it does not go retroactive. And that's what we're doing here today, Madam Speaker. It's very simple. And I humbly ask the senators who've been voted by the people of Guam to protect what they had been put in place in the past. Thank you, Madam Speaker.
Thank you, Senator. On the amendment, all those in favor? There's been an objection, so all those in favor, please raise your hand if you are in support of the amendment. Please raise your hand. Amendment passes. Senator Taitigui on the bill.
Thank you, Madam Speaker. I'll retire. Thank you.
On the bill, is there anyone else who'd like to be recognized on the bill? Senator Dueñas, you are recognized.
Si Diyos masi, Madam Speaker. I'm just going to make it short because, like I said, it appeared as I was speaking on the motion during my discussion on the amendment. But I just want to say I'm satisfied, and I think that this bill, at this point now, can realize the intent. Can realize the intent of what has been brought before us. I want to believe, and I do believe, because particularly title companies, having served as director for land management for a couple of years, I was, of course, aware of the whole process and worked with our team to continue to improve the process, and had to meet a lot of times with title companies and other folks who utilizes the resources of Department of Land Management. We've had many improvements over the years, and efficiency is a big deal. So I understand, when they find things that become problematic and have been problematic over the years, and that there is a fix to law going forward, wherein we can assure the efficiency and also bring up to date things that could be done statutorily. And I believe now that we are clear about, subject maybe, I don't know if there's any other amendments coming forward, but it's clearly stated now within Section 4 that this is going forward. I believe that attorneys, those other individuals assigned that awesome duty of assembling trusts, will be exactly aware of what the statute is, and also to advise their clientele that, be more explicit about your actual intent and desires with regard to what's going forward, because the law at this time basically is, if it's not there, it may be a durable document for those to dispose of the intent of the trust, with the true intentions intact of every word that's written in the trust. So for me, Madam Speaker, I know that this process has gone back and forth in terms of how statutes become effective. But now with this amendment, I can feel secure about voting to support this bill. Si Diyos masi, Madam Speaker.
Si Diyos masi. On the bill, is there anyone else who'd like to be recognized on the bill? If not, then the sponsor may close on the bill.
Madam Speaker, on the motion to place this Bill 93-36 as amended and further amended on the floor to the voting file.
On that motion, is there any objection? Seeing no objection, motion carries. We're now on Bill number 99-36 LS on second reading folder. Vice Speaker Tina Rose Munoz Barnes, you are recognized. Our rules say we will automatically go into Committee of the Whole on this bill.
Madam Speaker, if I can just have a moment's time, just so that I can check with the Committee on OFB, just to see what we can move from here. Moment's recess.
1 minute recess. We're back in session. Vice Speaker Munoz Barnes, you have the floor.
Madam Speaker, thank you very much. Considering that this Bill 99-36 LS is going to create a fund, and our standing rules specifically note that if anything dealing with funds, creating resources, that it should go into the Committee of the Whole. I will ask that we move then this bill to go to the bottom of the agenda, but right before Bill 121, so that when we do go into the Committee of the Whole, that we will be able to entertain the two bills then.
On the motion to pass the bill and place it right before Bill number 121-36 on the agenda. Is there any objection to that motion? Seeing no objection, motion carries. We're now on Bill number 108-36 COR. Senator Torres, you are recognized.
Thank you, Madam Speaker. I move to place Bill number 108-36 COR as amended by the Committee on Air Transportation, Parks, Tourism, Higher Education, and the Advancement of Women, Youth, and Senior Citizens, introduced by myself, Vice Speaker Tina Ronos Muñoz-Barnes, Senator Amanda L. Shelton, Senator Talina Cruz Nelson, Senator Jose Pito Terlahi, Senator Joe S. San Augustine, Senator Frank F. Blas Jr., Senator James C. Moylan, Senator V. Anthony Atta, and Senator Christopher Duenas into the third reading file. This is an act to amend Section 1302, 1308, and 1310B1A, and to add a new Section 1313 to Article 3, all of Chapter 1, Title 26, Guam Administrative Rules and Regulations, and to amend Section 4201C of Article 2, Chapter 4, Title 19, Guam Code Annotated, relative to streamlining adoption policies and procedures in Guam. And if I may speak on the measure further.
Please proceed, Senator.
Thank you. Speaker, we are deliberating this bill today because every child deserves to grow up in a safe and loving home. The state of Guam foster care is alarming. If we were to imagine this room, our hollowed session hall, filled with children, we would need not one, not two, but almost 3 of our session halls to fit the 450 kids currently in our foster care system. These children enter foster care through no fault of their own, while their birth parents are given the opportunity to complete services. Some stay with licensed foster families and others are in relative placement. But all of these kids are without a permanent home. Due to the temporary nature of foster care, many kids may undergo multiple placements, putting them at greater risk of post-traumatic stress disorder, depression, and drug and alcohol misuse. Studies show that the impact can be far worse for abandoned babies. According to the American Bar Association, infants entering foster care spend 33% more time in the system than older children. So in other words, if you start out in foster care, you're more likely to stay longer in foster care. I thank God every day for our social workers and the families who open their homes to children in need. But we should be working to prevent any more kids from having to enter the foster care system. That, in part, is what Bill 08 attempts to do. If enacted, these relinquished infants would bypass the foster care system and be placed into pre-approved adoptive homes instead of an arranged foster home. An adoption agency duly licensed under Guam law would facilitate the placement of these relinquished infants, drawing from a list of families approved by public health. Ensuring the baby does not go into foster care is important, Speaker, to reduce the trauma-inducing effect of multiple placements. Mrs. Bethany Taylor, a foster parent and the director of Harvest House, a ministry for foster children and families, stated it best at our bill's public hearing. She states, "When a mother in need comes to us and wants to put the baby up for adoption, I would hope that the baby would not have to endure the foster care system. I would rather that the baby be placed in a nurturing environment right away and be given a forever home. because permanency is very important, and I wouldn't want to see any more children have to go through the foster care system that don't need to go through the foster care system. Now, a question that came up at the public hearing was, well, why can't CPS just place these newborns in the adoptive homes themselves? Well, there are many reasons why a law-abiding adoption agency is better suited for this kind of placement. As my colleagues are aware, Child Protective Services is responsible for receiving and investigating all reports of child abuse or neglect. Its primary mission is to facilitate family reunification and the return of the child to a safe home. And this is in our 19 GCA. An unharmed, surrendered newborn should not have to enter our social services system. In addition, many critical service providers testified that an inpatient birth mother should have the option to make the choice of a family for her child. An adoption agency can work with a mother or an adoption plan that meets her desires, rather than a government agency making those important choices for her. In cases of anonymity under safe haven, the mother can at least walk away with the comfort of knowing that her baby will not have to enter the foster care system. I want to be clear, I applaud CPS for the work they've done for our children. But they have been at the helm of adoptions largely because there have been no adoption agencies in Guam until fairly recently. By inserting licensed adoption agencies into our adoption procedures for newborns, we provide a clear path for the rest of the baby's life. At this time, Madam Speaker, I'd like to take a moment to address the oversight concerns that were raised by the Department of Public Health and Social Services at the public hearing. I have heard the argument that we should not move forward with this measure because adoption agencies are not contemplated in local law and therefore have no regulations. This claim is both false and misleading. For decades, Guam has had laws in place that establish clear procedures and basic safeguards for the adoption of our children, regardless of who is facilitating the service. To this end, adoption policies are not only prescribed in Article 2, Chapter 4, Title 19 of the Guam Code Annotated, under the title Personal Relations, but also contained in Article 3, Chapter 1, Title 26 of the Guam Administrative Rules and Regulations. What's more, in the latter section, titled Adoption Policies and Control, the word agency is used 18 times throughout the article. This is not a reference to public health and social services, Madam Speaker, which is explicitly referred to as the department in this article. Likewise, Child Protective Services is only referred to as the division's Child Protective Services in this chapter. In Section 1309D4G, the GAR further requires that the termination of parental rights petition to be filed with the court contains the names and addresses of either the person having legal custody or guardianship or the organization or authorized agency. From this section alone, we can presume that organizations and entities outside of public health and CPS were contemplated in the adoption of our children. I also want to reiterate that all adoptive families, whether they work with a private adoption agency or not, must undergo an extensive screening process under Guam law. Bill number 108 doesn't change those requirements. Before an adoption can be granted, a judge must first terminate the parental rights of the parents. Neither the termination of parental rights nor an adoption can be granted until a home study has been prepared by a social worker from Guam's Bureau of Social Services Administration. This entails a rather lengthy written report that is submitted to the judge and is based on the adoptive parents providing the social worker with numerous documents, including employment verifications, income statements, court and plea clearances, recommendations, among others. There is then a home inspection conducted by the social worker. There have been concerns about foreign adoptions that were raised also, but according to the Guam Family Law Office, an international adoption is even more complex and time-consuming, taking anywhere from 3 to 6 years. As the office states, international adoptions fall under the regulatory umbrella of the Hague Convention's protection of children and cooperation in respect of intercountry adoption, also known as the Hague Adoption Convention. The adopting parents must retain the services of a Hague accredited service provider to shepherd the process through the U.S. Citizenship and Immigration Services Division of the Department of Homeland Security. Guam does not have any accredited service provider. Hawaii has the nearest accredited service provider. The service provider assists the adoptive parents in locating an adoptable child from a country that is also a member of the Hague Adoption Convention. Once a child has been identified, the service provider will guide the adoptive parents through the process of eventually bringing the child to Guam. The adoption process can only proceed after the child has successfully resided with the adoptive parents for 1 year. International adoptions can be a very long, expensive, and emotionally draining process. Madam Speaker, I took the time to go into great detail here to point out that multiple layers of oversight and legal structure that govern adoption, regardless of which entity is doing the placement. In short, the human trafficking concerns that were raised by public health at the measures hearing are totally unfounded and without merit. And quite frankly, I was quite shocked and expected more from our government officials. But nonetheless, I have amended Bill 108 in good faith and in collaboration with Director Lonnie Brennan after the public hearing. As the chair notes in the committee's findings and recommendation, a new Section 5 was added to the bill to do the following: to give DPHSS explicit authority to conduct annual audits of adoption agencies without limitation for information relating to complaints, investigations, and adoption services. Second, to allow DPHSS to issue written notices to adoption agencies who are not in compliance with applicable laws. And third, to require the adoption agencies to submit a plan of action to address the areas of noncompliance. Together, these requirements mandate public health to do what every state does to ensure compliance with their laws. It is on the government to review files and audits and ensure that the agency is complying with state laws and adoption regulations. According to an overview of state regulations, when an agency is licensed in many states, they get reviewed multiple times per year by each state's government. Essentially, this creates an extra layer of safety and dependability for clients. While some states have developed special licensing procedures for adoption agencies, this is often coupled with an entirely separate division or board within their public health department, as well as the promulgation of rules and regulations. I have no issues mandating that public health establish rules and regulations for the certification of adoption agencies, Madam Speaker. I'm just listening also to the struggles that Director Brennan has stated her agency is currently facing, that the Bureau of Social Services is, and I quote, already overwhelmed. Mandating an annual audit that ensures adoption agencies comply with current adoption laws serves as a compromise without overburdening public health to establish new certification requirements for an already existent adoption agency. In closing, I just want to thank Director Brennan as well as the chair of the committee for working with me on the amended measure that I'm happy to say satisfies the director's oversight concerns at the public hearing. Bill 108 simply says that if our goal is to find a home for every abandoned infant, adoption agencies can help facilitate placement, and our laws should reflect that. Bill 108 is a measure towards that goal, and I respectfully ask for my colleagues' continued support of this very noble effort. Sizus Maasi.
Susan Mossy, Senator. On the bill, Bill 108, Senator, Vice Speaker had her hand up earlier. Oh, she'll yield to Senator Shelton. You are recognized.
Sizus Masi, Madam Speaker, and I rise in support of Bill number 108-36 COR to provide permanency and safe, loving, forever homes for our children. I thank the author of this bill for reaching out to me as a co-sponsor and working together with the committee to strengthen this bill and to come to a piece of legislation that we were all comfortable with. Currently, infants are placed into foster care if relinquished under the Newborn Infant Safe Haven Act, with nonprofit adoption agencies now established on Guam, and I want to thank our partners at Ohala Adoptions for the great work they are doing. We can now include these adoption agencies into the chain of custody for infants so that they can be placed with pre-approved families instead of in foster care. I want to further underscore, as the author did, the importance of providing permanent homes for our children. With such a staggering number of children in foster care, over 400 and less than 50 licensed foster care families on Guam. We have an opportunity here today, Madam Speaker, to make a significant change in the lives of Guam's children. We have the opportunity to make families whole. As chair of the Committee on the Advancement of Women and Youth, we held a public hearing on the bill last month, and we solicited input from both our public and private stakeholders. And in the hearing, we received testimony in opposition to the bill initially from the Department of Public Health and Social Services and the Child Protective Services. And the committee took these concerns very, very seriously. We did our due diligence along with the author to ensure that the bill was not reported out until a consensus was reached. And so, as was mentioned, I'd like to note again for the record that the committee amended the bill as recommended by Director Brennan at the Department of Youth Affairs Child Protective Services to give DPHSS explicit authority to conduct annual audits of adoption agencies without limitation for information relating to complaints, investigations, and adoption services, to allow DPHSS to issue written notices to adoption agencies who are not in compliance with applicable laws, and to require the adoption agencies to submit a plan of action to address the areas of noncompliance. Madam Speaker, we now have the resources and the capacity to ensure that our children are not subjected to trauma from multiple placements in the foster care system, but to be placed in safe and loving homes. And so we owe it to them to get this done, and I ask our colleagues for their support of this bill as well. Sizus Masi.
Sizus Masi. On the bill, Vice Speaker, you are recognized.
Sizus Masi, Madam Speaker, and thank you for giving me the opportunity to rise in support of Bill 108-36 COR, and I want to thank the good author, her main author from Santa Rita for giving me the opportunity to be her second co-sponsor on this bill. And as I share the same sentiments of the two retiring speakers, Madam Speaker, I want to say that the intent of this bill intends to amend a couple of sections in our Guam Code annotated. And if I had to do the who, what, why, where, and when, you know, this who would be to work with the adoption agencies. What will it do? It would amend Article 3 of the Guam rules, administrative rules and regulations, and Article 2 of the Guam Code annotated to include language that streamlines adoption policies and procedures. Of course, the where is here on our island, and God willing, if this gets through and the governor signs it, it'll be effective upon enactment. And this would also include adoption agencies and the adoptive care options. As I said, it includes adoption agencies in the process. For me personally, it allows for a child to be placed in an adoption agency licensed under Guam law. The child can live in an adoptive home for up to 1 year instead of the 1 year exactly in prior law. And an infant relinquished under the Safe Haven Act will not require a meeting under the ASC. Madam Speaker, the BBMR, the fiscal note, was submitted to this, and they noted that this bill is administrative in nature, so it has no fiscal impact at this time. I will note, based on the committee chair who worked closely with the main author of this bill, that the amendments have been made, and a new action was added to satisfy and address the concerns of the acting CPS director, Director Melanie Brennan. And I would think my synopsis on this is: one, it'll give the department explicit authority to conduct annual audits. Two, it would allow the department to issue written notices if agencies are not compliant. And three, it would require agencies to submit an action plan. So, Madam Speaker, I rise in full support of this bill, as we know that we want to make sure that our children find a place that they can call home and know that they will definitely be protected. And having to be there at the public hearing and hear the concerns, I'm glad that the good chairperson heeded to the amendments and included in. So, Sidzus Masi, and I ask that my colleagues please support us in this effort and support this measure 108-36 COR. Sidzus Masi.
Sidzus Masi. On the bill, Senator Taitakui, you are recognized, and then Senator Duenas.
Sidzus Masi, Madam Speaker, for the opportunity to speak on this measure. You know, I attended the public hearing, and it was pretty, apparent that public health, as well as Mrs. Brennan from CSC, who testified not in favor of this legislation. And as I was reading through it, Madam Speaker, and listening to what they had to say, and I have to say that my hat is off, and all kudos that I can give to public health when it comes to social services and handling children going into the foster care. They're doing an excellent job. And in fact, if I'm not mistaken, that they are doing that. Test Archangel mentioned they are doing the job. So, Madam Speaker, when I looked at this legislation, first I thought to myself, what adoption agency? We have an adoption agency on Guam. So I looked at an article that was out on Guam Daily Post, 2019, December 1st. And it talks about a woman, Lori Boss, who grew up in Oregon, and talks about her background and talking about children in Korea who are being adopted and brought to Oregon. And how she thought, she wanted to do the same thing. I wanted to ask her what brought her to Guam to open up an adoption agency. What are the data and statistics that she's been receiving that Guam has an abundance of mothers giving up their children? Safe Haven was introduced, I think it was in 2018. And it was an opportunity to decriminalize, mothers who could not take care of their children and leave them for someone else to care for. It was a good bill. And I tried to ask public health, well, what are the numbers? How many women are taking advantage of Safe Haven within the year? Is there an abundance of women that are giving up their children? One of the things that I've learned that it's important to keep our children here on Guam, those who are being adopted, to keep them within their culture, to raise them here. So after looking at that and wondering how this woman came here to Oregon and what did it take for her to open up an adoption agency, so I met with the Reverend Tax, Daphne Shimzu, who issues out license, and asked her, what does it take in order to open up an adoption agency? Just a business license. There are no guidelines. There are no rules or regulations on opening an adoption agency. And, first in my mind, I said, I think there should be. We should have something in there that shows the guidelines that work with public health before they even open up an adoption agency. Madam Speaker, I had the opportunity to call Hawaii and one of the adoption agencies in Hawaii and talk to them about their procedures and what they go through in order to open an adoption agency. And some of the rules and regulations they have to go through and adhere to before even opening up one, it made sense, complete sense. Background checks, the area in which they're doing their work, where they're doing it, how they're helping women in case they don't want to give up their baby, what are they doing there? And there's nothing indicating on the website of this adoption company that actually does that. It only is about adopting children from Guam, but there's nothing in there about helping women who are thinking about keeping their baby, because that's the best interest of the child sometimes, is staying with a mom. And usually these women, they want the best for their children. They don't know which way to turn, but adoption agencies almost in some states are becoming a commodity. There are more people out there who cannot have children than there are children being born for adoption agent in the U.S. Madam Speaker, I contemplated adopting because I was told that I couldn't have children, that I had issues medically, that I couldn't have them. So this touches very deeply to me. I mean, I was God, the one that decides, because even with those doctors telling me that, I did. I had 2 beautiful children, and I'm blessed with that. So this really hits hard to me when it comes to adoption and people who can't have children being able to have a child of their own and care for it. But Madam Speaker, these are our children of Guam. And we need to ensure that they're safe. Adoption agencies on Guam There are no guidelines, rules, and regulations stipulated by revenue tax and also public health. The bill that was talked about in front of us at the end of the bill, where it brings in the section, annual audit records for adoption agency. So it's agencies, adoption agency duly licensed under Guam law. Well, to be an adoption agency, all you have to do is go to revenue tax and get a license. Boom, you're done. You're an adoption agency. But here in 1313, it says annual audit of records of adoption agents within 180 days of enactment of this section, and thereafter annually, the Department of Public Health and Social shall audit the records of an agency which proves adoption services in Guam to be determined compliance with provisions of this chapter. Chapter 4, Title 19, Guam Code annotated. Why are we putting the cart before the horse here? Why are we doing this? We should have these rules and regulations and guidelines in place before we issue out adoption agency license. Whether it's a nonprofit organization or a private company, adoption agencies that want to open up on Guam should have these guidelines because, Madam Speaker, I can tell you right now, the word gets out, which now I've heard from Hawaii that if the word gets out, Guam, come to Guam, open up an adoption agency. You don't have to follow any rules or guidelines. You can just get your business license and open up. I had an opportunity to speak with Alicia Limtiaco, too, to go even further about human trafficking. I know she did a lot of work on it. And even she said, there should be guidelines and rules and regulations before anybody should open up an adoption agency because of human trafficking. Because children, and these are not her words on this last part, but on another article, that children can be a commodity. It's very scary, Madam Speaker. I'd like to read something for you, Madam Speaker, here into the record, and I'll provide it. January 8, 2021. Baby selling scheme. Poor pregnant Marshall Island women lured to U.S. Rolson Price still scams Facebook for her picture. He's seen her occasionally, and someone else's photo, instantly recognizing. But he's never met her and concedes he never will. But he still doesn't know his daughter's name. Price is one of dozens of victims of many extraordinary and brazier human trafficking ring operating for years across the Marshall Islands. This is in our backyard, Madam Speaker. The Marshall Islands archipelago and 3 states of the United States of America. The scheme involved pregnant Marshallese women being lured to the United States and enticed with offers of $10,000 and a promise of a new life in America to give up their babies, which were then adopted out to U.S. couples willing to pay 4 times the amount for a child. Prosecutors believe at least 70 babies were adopted this way, sold in a court scanning judgment for up to $40,000 each. Paul Peterson, a 45-year-old former elected county official in Arizona, pleaded guilty to human smuggling, conspiracy to smuggling illegal aliens, and fraud in U.S. federal court, has been sentenced to 6 years in prison and faces further jail time still on more charges. But across the Marshall Islands, families have been left irreparably damaged. Fathers who will never know their children, children left without their mothers. And it was stated here, a bomb going off inside your house. Quote, for years the U.S. used to drop actual atomic bombs in our backyards. A reporter in Marlborough who acknowledged of the scheme told The Guardian a reference to America's massive 20th century nuclear testing regime which devastated the Marshall's environment. But this This is like a bomb going off inside your house, in your family. It destroys everything. You can see this on the Pacific Project Marshall Islands report in its entirety. It goes on to talk about how this is becoming more and more easier for individuals to do this type of human trafficking. Makes me wonder why a girl from Oregon comes to Guam again to open up an adoption agency. We're not supposed to make this easy on this island. We're supposed to scrutinize things and ensure that our children are safe. Madam Speaker, also online you'll find out how to adopt in Guam. But it has nothing about adoption agencies on how to open up an adoption agent. It's just how to adopt on Guam. And there's a section here is when and how can birth parents consent to adoption. Guam adoption laws do not specify a time frame for birth parents to wait before giving consent. Consent must be acknowledged before a notary public and witness by representative of the court. There is adoptions going on today here, Madam Speaker, in Guam. It goes through a process through public health. It goes through the courts. And they follow rules and regulations. So, Madam Speaker, in fact, they also list family law offices and the law office of John Terlahi. These are individuals that, if anyone is ever interested in adopting, it can be done on Guam. Madam Speaker, there are certain things that are very concerning in here that I mentioned earlier. There's a section here that they talk about how many of these families will now lose children to adoption when a family member might have been able to care for the child. That's a part of our culture. Guam is notorious for that. When the mother gives up a child, it either goes to grandma or it goes to an aunt or an uncle. We practice this quite a bit here on Guam. We're a huge family. I mean, my father is one of 8. And many of our parents come from large families. We have a community here that looks after each other, that we don't encourage adoption outside or taking our children off this island to somewhere else, and that's exactly what this adoption agency could do. Madam Speaker, the bill itself, like I said, does not really provide, it's the cart before the horse. It does not put into place, and the author of the bill talked about Bethany Taylor, mentioning, and everybody knows who Bethany Taylor is, but mentioning through her, even she said during the public hearing, and you can find it on the committee report, even she says that this bill should have a roundtable discussion. She concurs with public health about having a roundtable discussion. I'm going further into this. And Madam Speaker, I know my time is almost coming to an end here. One thing that was brought to my attention is on page 3 of the legislation, but it starts on page 2. The composition of committee. The adoption section committee shall be composed of, but not limited to, the following 5 ongoing members: adoption supervisor, natural parents caseworker, adoption caseworker not involved in the case, a 3rd social worker, other staff assigned by the adoption supervisor, and then number 5, a representative from an independent adoption agency. Madam Speaker, this is a committee that oversees where a child should go. This is a definite conflict of interest. You're getting a private company, whether nonprofit or not, is a private entity, being part of a committee, screening that committee that decides where the child goes. So, Madam Speaker, the first amendment I would like to do is to strike out number 5 because of the conflict of interest. So I didn't have it in writing, Madam Speaker. If you can give me a minute, I can have them just strike it out, but it's just very simple, just taking out. Well, actually, we'd have to go to page 3, where it says following 5 ongoing members should be 4, and then eliminating a representative from an independent adoption agency. I mean, I can't make it any clearer how much of a conflict of interest this is, because this is an independent private company who deals in adoptions, should not be a part of this deciding factor. So, Madam Speaker, if you'd like, give me a minute, I can ask legal to assist me to drop the amendment.
Yeah, we're going to take a 5-minute recess. back in session. We took a recess to consult with legal and to have some floor amendments prepared. Senator Taituku, you're recognized.
Sijus Masi, Madam Speaker, and thank you, my colleagues, for your indulgence in this. Madam Speaker, you can find my First Amendment on page 2, line 24. And it basically just strikes out the fifth committee member. Madam Speaker, I want to explain to you what the AS Committee is, which is the purpose of the Adoption Screening Committee, the ASC, has the responsibility of reviewing adoption applications and eventually selecting adoptive parents for each child legally available for adoption and or given up to this agency for placement. That's the responsibility of the ASC. So, Madam Speaker, when you're going through this and determining the deciding factor on where the child should go, we know that an adoption agency is basically a business. I'm sure they receive funding. There are salaries that are being paid. It's a business. And it's definitely a conflict of interest. A representative from an independent adoption agency can woo this committee into their favor. Like I said, Madam Speaker, we're opening up the door here for anybody to come to Guam. It's obvious we have a person who came from Oregon who decides to set up shop here for an adoption agency. It doesn't stop anybody else from doing the same thing, especially when you don't have any rules and regulations in place. And it's as simple as just going to Rev and Tax and getting a license. So putting them on this committee, on the deciding committee for the child is, in my book, Madam Speaker, is a total conflict of interest. So I ask my colleagues to please support this and recognize the difference. That this is, again, a conflict of interest. Thank you, Madam Speaker.
Thank you, Senator. On the amendment, Senator Perez, you're recognized on the amendment.
Thank you, Madam Speaker. I rise in support of this amendment. In looking at the current statute, too, it goes on further to say that potentially this committee member from a representative from the independent adoption agency could actually end up being the committee chair. They could also be involved in, so it says the chair shall assign each applicant to a committee member to interview individually and to conduct a pre-adoption home study. So there's also potential that this representative from the adoption agencies can also interview one-on-one the applicants. And so again, you know, it goes deeper to perhaps, by including that in this bill, it does create a bias throughout the process. And it could be even greater if this person becomes the chair of the committee. And I do agree with the proffer of this amendment that it is introducing a conflict of interest that needs to be removed. Thank you.
Thank you. On the amendment, is there anyone else who'd like to be recognized on the amendment? Senator Brown, you are recognized.
Thank you very much, Madam Speaker. I also rise in support of the amendment. I think we all recognize, certainly, and I think we would all desire, Madam Speaker, that all our children, and those certainly that are in need of a good, caring, stable family home, that perhaps because their own parents or parent was unable to provide that, I think we all want to see it. I think we all would like to have that in our island and in our community. But I think as we go about that process, I think it's a process that we also need to be very careful how we're facilitating that, to make sure that through that evaluation process, and so far that process has been invested with the government. Government itself, of course, is not perfect, but we've seen circumstances in other jurisdictions where this process has been abused. where sometimes the agenda of these agencies have not been in the best interest of the child, but in the best interest of those that have an interest in wanting to make profit. I recognize the one agency that testified at the public hearing, which I also participated in, has the best interest. I mean, I hear it. I hear what they're saying. But as the main sponsor of this amendment had mentioned, there's nothing to prohibit any other agency from coming in or another agency from being created on Guam. And we don't know what those standards are. How do we evaluate who these agencies are that are taking custody of these children? How are we monitoring the process to ensure that once that child or children have been transferred over, that indeed they are going to safe, caring homes? Right now, while the legislation here proposed, it in concept looks good, there's still a lot of unknown factors, and certainly by putting the adoption agency as part of the evaluating committee, where it itself has a specific agenda, I do see it also as a conflict. And so I certainly rise in support of the amendment that would remove an adoption agency, because then this bill doesn't even tell us how that adoption agency gets determined. How do we know another agency is not going to be created tomorrow? How do we know another agency from the mainland or other places are not going to come in and try and establish here on the island? So with all those unknown factors, I would prefer that adoption agencies not sit on the evaluation committee. While the government itself, of course, has its limitation and its challenges, at least it has a process of accountability. And right now, I have no comfort level that an unknown adoption agency can provide that. I think until we know what those standards are, and there's a way to ensure and review that, of OHALA, who testified, or any other adoption agency that may decide to establish itself, I don't have any comfort level with regards to that. So I certainly rise in support of the amendment. Thank you very much, Madam Speaker.
Thank you very much. On the amendment, is there anyone else who'd like to be recognized on the amendment? If not, then the sponsor may close on the amendment. Senator Taitagui, you are recognized.
Thank you, Madam Speaker, and I thank my colleagues who stood up to talk about this amendment and the importance of it and recognizing the conflict. And I appreciate it, and thank you, Madam Speaker, and I humbly ask for my colleagues' support on this.
On the amendment, this is on line 24, page 2, on the amendment. There's an objection. All right, there's an objection. So all in favor of the amendment, please raise your hand. Amendment fails.
Thank you, Madam Speaker, for that opportunity. I also have another amendment, Madam Speaker. And this is on line 13, page 3. If I may, Madam Speaker, speak on this amendment.
Line 13, page 3, please proceed.
Thank you, Madam Speaker. Madam Speaker, in the legislation, proposed legislation, it says that making arrangements for the group to meet initially as soon as possible, but no later than a month prior to the estimated date of delivery of the natural mother. Incorporated in the current law is the inclusion if the, and then child is already born, the older than 1 month old, the ASC shall meet as soon as possible. And then it says, incorporated into the current law, an infant relinquished under the Newborn Infant Safe Haven Act pursuant to Article 5, Chapter 13, Title 19, Guam Code Annotated, will not require a meeting under the ASC. Madam Speaker, I think every child, whether the child is 1 day old, 5 months old, 1 year old, 2 years old, there's a process in place, at least, thank goodness, there is a committee put in place to determine if a child, where the child will go, where that child will be placed. Why are you taking out this committee's authority to do that, whether the child is just a newborn or not? So what my amendment does, Madam Speaker, is it strikes that out. It takes out an infant relinquished under the Newborn Infant Safe Haven Act pursuant to Article 5, Chapter 1319, Guam Code Entry, will not require a meeting under the ASC. You know, it's bad enough this legislation doesn't have any guidelines or rules and regulations before somebody decides to open up an adoption agency. You know, Madam Speaker, I spoke to the Deputy Director of Public Health, who told me directly that he did not support this bill moving forward without a roundtable to discuss these guidelines and rules and regulations that should be in place before we go forward. We're talking about children here. It sounds like in this legislation, what we're doing is helping this one adoption agency, whether a nonprofit or a private company who comes to Guam and opens up, that we're assisting them, our government, to give over our children to this company. A company that did not even go through any kind of regulations or requirements to open up. We should not stop the process, Madam Speaker, that is in place, that does some type of scrutiny, that looks into the areas of location for the children to go to. So, Madam Speaker, I ask that my colleagues, please, let's keep this process in place, if anything. Have this committee who's been put in place to review and decide where this child should go. Thank you, Madam Speaker.
Thank you, Senator. On the amendment, Senator Torres, you are recognized on the amendment.
Thank you, Madam Speaker. May I please explain something that maybe is not apparently clear? The line 13 reads, "An infant relinquished under the Newborn Infant Safe Haven Act will not require a meeting under the ASC." Under the Newborn Infant Safe Haven Act, it allows for a mother to relinquish her parental rights anonymously, to drop off a baby. And if she doesn't come back in 48 hours, that baby is free to be placed for adoption. It's an abandonment of a baby. So the mother would not be in a meeting to discuss the selection of the home for her baby under that pure definition of what Newborn Infant Safe Haven Act is. Also, let's also remember that under this idea too, the role of the independent adoption agencies in the Newborn Infant Safe Haven Act is for them to already have a list of pre-approved families that are already cleared, that have gone through all the studies, all the background checks, the homes, everything, that would be suitable families for children. So they're on a list. So when a baby is abandoned, given up in a safe haven scenario under our law, Article 5, Chapter 13, Title 19, once that baby is free within the 48 hours and cleared, it is healthy, its mother doesn't want the child back, the mother gives the child up, that baby will be placed in a home that has already been pre-screened. That's the idea here, pure and simple. So there is no mother to interview. There is no meeting required because all the prerequisites for choosing that family have already been met. And so that's why this is a very appropriate amendment to that section of the law. I hope I'm clear, and if some of my colleagues didn't understand what I was trying to say, please ask me so I can reiterate what it is that I'm trying to say. Basically, there's a waiting list, pre-clearance, baby's free to go. There's no mother, it's anonymous. Place the baby. No need for a meeting. There's no one to come to the meeting anyways, because she's given up her baby anonymously under the safe haven. She saved her baby's life. We're trying to place the baby in a home that's already been identified and cleared. Very simple. This was Masi.
Seduce Masi. On the amendment, Senator Dueñas, you are recognized.
Sidus Masi, Madam Speaker. I certainly understand the need to discuss what's been proffered in the amendment. Madam Speaker, in my comments on the bill and the motion, the main motion, which I will have at some point, I contemplated that we would be talking about some difficult situations on our island. This bill contemplates a happy opportunity for a child to be in a home of a wanted and loving family. I think the reason, and I was confused a little bit myself, Madam Speaker, I think the reason why GMH in particular and the administrator testified in support of this bill is because I know that the retiring speaker, the author of the Safe Haven Act, was influenced by a lot of what happens at GMH. One of the worst issues is the scourge of the ICE epidemic on Guam is children born with addiction. And parents, because of extenuating circumstances, a lot of times in that situation, decide that they cannot take care of that child. I agree with the retiring speaker on the reason why the ability to have this alacrity of placement, and even another one of the nonprofits made that very clear during their discussion on this bill. That they in themselves have encountered problems with pregnant women who have made a clear decision that they want their child to have a better life than they think that they can provide. But it is also in these difficult situations, I hate to have to use this term, but children who have been placed and have been adopted, ICE babies, have been freely given up. And the need for that child is heavy, because that baby not only needs a loving home, but it usually has issues already because of the carryover effects of the scourge of methamphetamine. So I want us to be very balanced, to move forward on what could be a beautiful thing. And yes, I understand, and I'll talk about regulatory issues and the like on the main motion. But I also want us to be clear about what exists in our community, unfortunately. And why sometimes when a mother of a beautiful child, a beautiful being of God's creation, and that excruciating decision to separate themselves from that joy is not typically done under the best of circumstances. And the provision that was allowed for in the enactment of the safe haven is exactly that. It is a time when, unfortunately, all rights have been relinquished by free will. And the government now is the custodian of this most precious of resources of life, life itself. And so I'll continue to listen, but I caution that this act is specific and was designed for a reason. Because not too long ago, and I'm glad we haven't seen a report in the news in many years, but not too long ago, there were infants, babies, that have been placed in various places, hoping that somebody would find that life and make something wonderful and beautiful under a tragic situation. So I think the statute as it's currently constructed is adequate, and as the author of this legislation says, it's not a requirement because all of the rights have been given. And the meeting is the custodial obligation of that child. And when you have a nonprofit organization, an agency that's been crying out, I'll enumerate on that with my discussions with the director who got more information, who was originally against this legislation, Ms. Brennan, who got more information. I'll elaborate on that later. But I think that the way the statute is and what's being added to the statute is in confirmation of a law that was passed by this body that's designed to protect the life of that child and to get it to a loving home as soon as possible. Si Jesús Masi, Madam Speaker.
Sidus Masi. On the amendment, Senator Brown, you're recognized on the amendment.
Thank you very much, Madam Speaker. I rise in support of the amendment. Again, I don't think anyone here will argue the importance of wanting to see that children that are in unfortunate circumstances, certainly not by their own choosing. I mean, we've seen circumstances time and time again on Guam, as we do in other places. For whatever reason, a parent is unable to take care of their child. It could be age, it could be their circumstance economically, it could be the stress levels they may, there's a whole bunch of factors, perhaps even drugs, as was mentioned by the previous speaker. I mean, I often recall, last year, was it last year, Madam Speaker, when these young children were found in an abandoned container home up in Jotnia. Every time I hear these kind of stories, it just frustrates me because, we talk about how important our children, how precious our children are. We think of our own children. I'm sure for those of you that have grandchildren, there probably could be nothing more wonderful in the world than your grandchildren or your children. So no one argues that. I don't think any of us here are in opposition to wanting to do that. And everything doesn't work into the perfect family picture. And even when people have their own families, the family is not the perfect family picture in terms of how they may exist or how they may care or take care of each other. I mean, every day practically, Madam Speaker, we read about the abuse of our children. Almost every single day we read about the abuse of our precious children in this community, especially sexual abuse. You think there's no boundary, and then you end up going, my God, what the heck is going on? Nobody argues that. Who here wants to see that continue? But I would also want to ensure that as we address legislation as policymakers, that to the best of our ability, we're also ensuring that the process that's being put in place is going to also protect those children and not further victimize them. Like the children I was talking about that we found out about in Jotnia, where these children had no food, had no water, had no adequate shelter, had not been taken care of, were hungry, were not cleaned, had no supervision, and then only to end up finding out that both the mother and the father were on drugs and were not taking care of their children. Their own priority for their own selfish needs overrode the interest of protecting these young, defenseless children, our own people in our own community, in our own island. So none of us are going to argue about the importance of wanting to ensure the protection of our children. But right now, we're looking at legislation that's going to include an adoption agency, which I have yet to see, Madam Speaker, what the standards are of evaluating this adoption agency or any other adoption agency, especially when time and time again we've seen in our community, not here, but in other jurisdictions in the mainland and as recent as the situation in the Marshall Islands, where there's abuse within that system. Because yes, there is a market for people that have the resources to pay for children. We just kind of do it through what we call a sort of official way. But how are we protecting these children? And certainly we also recognize, I mean, look at the situation of the mother that we heard that showed up at the hospital with her dead infant. And she was charged with murdering that infant. Those are the horror stories that we all are just, that really hits you in the most vulnerable place, because you can't imagine, how can a mother kill her newly born baby? And so certainly these are terrible, horrific circumstances. But how are we ensuring through this process and us wanting to do all these good, wonderful deeds, are we ensuring that these children are going to be protected? I appreciate the input of Ms. Brennan from Department of Youth Affairs. I don't know her background, if she previously worked in Child Protective Services. But there were also other public officials from public health that testified at that hearing, and unless they've changed their position, I haven't heard it yet, that also agreed that further discussion and deliberation should occur. And I don't know what the rush is with regards to this bill in not doing that. Granted, we so recently heard as well of the backlog of cases of our own children in this community that had not been addressed for some time, and DYA was included in that process to help facilitate the cases. And I also am aware that they brought in former retired members of public health that used to work with Child Protective Service to help and assist to facilitate, to address the needs of these children that were backlogged. But while we're doing that and trying to address the deficiencies, how are we ensuring that the process is better? How are we ensuring that these adoption agencies, not only are they qualified, but what structure do they exist under? What are the standards? Who's going to monitor that? What is the house that we're building? I don't see that defined, because I don't think it's going to be limited to simply this adoption agency that testified at the public hearing. Who else can open an adoption agency? What other adoption agency could move into Guam and be engaged in this process? I think these are very legitimate concerns that are being raised, and I think if in our desire to do good deeds and be recognized for our good deeds, are we creating other problems? Or are we going to wait to find out that a child ended up being harmed in this process? It's nice that the families are evaluated, but what other steps are we taking to ensure that that child is in a good situation? I don't know, Madam Speaker, if I, within 48 hours, could ever ultimately determine whether or not I wanted to be a mother, because I may have been under a stressful circumstance. Maybe the birth of my child was not something intended. Maybe I could have been raped or abused. But I think we need to be cautious with this. I think we need to have further discussion and deliberation rather than rush to get this bill on the floor. This bill was just heard a few weeks ago. Rather than this mad rush to get on the floor to deliberate with all these questions that still exist. What is the big rush? These are serious matters. We're not talking about property. God, in the previous bill, we were talking about property. Now we're not talking about property. We're talking about living, breathing human beings that cannot take care of themselves yet. And what are we doing to address that? What are we doing to ensure what the parameters are for these adoption agencies? What are the structure under law for these adoption agencies? What's the level of accountability of these adoption agencies? Because now Guam, perhaps, maybe we are moving beyond just the families. When a child was not able to be taken care of by their birth parent, had an uncle or an aunt or a cousin or a grandparent. Now, even in this day in Guam, grandparents. I often talk to my mom and she surprises me when she tells me. Sometimes I might ask, oh, Mom, why is so-and-so still working at their age? You know, they should enjoy their time and be retired. And she'll tell me, Ayade, you know, they're taking care of their grandchildren. And I'm like, well, where are their parents? Where are their adult parents? Oh, they're not taking care of them. So the grandparents have interceded to raise that child. They're in their 70s, mid to late 70s, and they're having to raise their grandchildren because their own children to whom they have raised are not there to take care of their grandchildren, of their own physical children. So there's all kinds of circumstances, certainly from the time when we grew up on Guam. But in our urgency to do that, Madam Speaker, by not addressing, which I think are very legitimate concerns that certainly the sponsor of this amendment has raised, and certainly my support of it I'm raising, I think we need to know the structure of these adoption agencies and not simply put the face of simply the one adopts an agency, which I'm sure from their testimony has the best of intentions. But none of us are here forever. No matter what our current positions are, we are not here forever, and the current members of this adoption agency are not forever going to be with that adoption agency. So what we put in place should survive us to ensure that we have a structure that allows for proper review, because we are putting a child up, hopefully in a good home. That is always the desire, and I have no problem with that. There's a need for it. But what is the structure that's put in place to ensure that that is going to happen? I don't think we should get caught up with our need to feel good about all this and pat ourselves and look at a wonderful thing we're doing without ensuring that these protection measures are in place. And while we have one director from DOI that's saying, oh, I support, maybe she does, I don't know. She hasn't publicly said that. I haven't heard it yet. But public health has always been the primary entity in our government that has dealt with child protection. And maybe I should call my dear first cousin, who was in charge for many years of that division, and ask her thoughts on this, because I think I'm going to do that. Because she has certainly far more experience with dealing with these circumstances with children. But I think we need to be a little cautious in our run to push this bill through. I think we need to review this issue. I want to know what the requirements are to be a licensed adoption agency on Guam. What are those requirements? What is the review process? And does public health have the resources to expand to do that as well? Because I'm not aware of an existing adoption agency on Guam. Prior to Ohala, I don't know what the requirements are for them to come into existence. What is the regulatory review of that? Normally, now it's done through a formal process through the court, unless a parent maybe has an agreement with an adoptive parent that they would like to have their children be raised by. And then, of course, they go through the legal process of that. But while we're venturing into this new ground, it may be a very good and productive thing for our community, I think we need to use a little caution here and a little pause, because I don't see that information coming forth. And I would like to have some comfort level from public health that they're going to be able to do what we're saying. Oh, they're going to go and they're going to check in, they're going to follow up. That's great. Are they going to do it? I don't know. I'd like to ask them that question. But the fact that we collectively, at least for those of us that participated in the public hearing, I have heard no further dialogue open to us and open publicly. We can all have our own personal phone calls, but I've not heard any further public discussion of public health coming back, or our ability as legislators even be able to ask them further questions on this matter, so that there are some safeguards that are put in place. Because if public health was challenged, Madam Speaker, not too long ago to be able to address the caseload of existing children. And of course, we all love babies. Who doesn't love a wonderful, they're so mungy. You just can't help but smile when you see a baby. They just light your life up. But what about all those other children, huh? They grow into those difficult teenagers. But I want to know, how did that situation happen in the first place? I'm glad that they publicly announced they've addressed it, but I think we all should be concerned, how did that happen? Because these children are left hanging in this situation. But in our rush to want to do good, let's not create another bad situation by having answers to these questions, by having these public officials that, again, because they are public officials, have a degree of public accountability. It's a little different from a private adoption agency that I have yet to know what the structure is that they exist under. What are the restrictions? Are they simply as a not-for-profit, we're not going to take any more money than what it takes? What is it going to cost to do that? It does cost resources and money to transfer this whole How is that going to happen? What are the limits financially so that we ensure that this doesn't become a for-profit? Because we've seen circumstances. We heard for the longest time about the Marshall Islands. Fortunately, that issue was properly addressed. You had someone who came, who was part of a church. Part of a church. Gosh. They're there to help the community, not just enlighten them with the Word of God, but we're here to help them better their life and their circumstances. That's part of our mission. And then ends up coming back after being a part of that community, learning the language of the people, and then in mass taking these children, taking these mothers that are pregnant, exploiting them because they have very little means financially to live in their own island, take care of their own children. Being paid $10,000, is that enough for your baby? $10,000? And then other families, of course, of affluence who can afford it would be willing to pay $40,000, $50,000, probably more. So we know there's a market. There's a market that exists even within our own country. I think we need to think about that. We really need to step out of ourselves and think about that and make sure that these measures are in place to protect these children and ensure that there is an oversight process, so that in our desire to want to facilitate the movement of a child from an unfortunate situation to hopefully a better situation, there's some protective measures that are put in place, ultimately for the safety of that child. That should be our first and foremost priority. And with that, Madam Speaker, I still rise in support of this amendment.
Thank you very much, Senator. We're going to recess tomorrow until 9 a.m. We're going to recess.